Okay, we are recording and live. Good morning. It is 10 a.m. at the time appointed for the Executive Committee of the State Bar Board of Trustees. Thank you for those of you who are participating remotely. Thank you for any members of the public who may have tuned in to join us. I'll call the meeting to order and ask the secretary to take the roll, please.
Chen? Here. Cisneros?
Here.
Delenn?
She's here.
Duran?
Here.
Sol?
Here.
Stallings?
Here.
You have a quorum.
Thank you, Madam Secretary. This is the opportunity in our agenda for members of the public to speak to the Executive Committee on any item on our agenda or within our purview. Is there anybody who would like to speak to us today? If so, please indicate your willingness by clicking the raise hand function on Zoom.
I see 2 hands raised at the moment, 3 hands.
Okay. Each of the members of the public who would like to address the Executive Committee will have 3 minutes to do so. And when you're recognized and your microphone is activated, please go ahead and start.
I have Jules Sarkar.
Mr. Sarkar, please. Good morning.
Thank you, ma'am. Good morning, sir. Thank you. My name is Julian Sarkar. I represent attorney applicants against the State Bar and the NCB's unlawful practices. I'm here today to object to the State Bar's proposed fee increase and also its claim that the fee increase is caused by diversity, equity, and inclusion. Several years ago, the State Bar removed what has now become the California Lawyers Association that collects its own dues, and the State Bar proposed increasing its annual fees by nearly 3 times as much. It seems doubtful that it is much more expensive to provide fewer services. Our state auditor provides regular reports on the State Bar's spending. There are numerous critiques on the State Bar's spending, but none of those critiques seem related to diversity, equity, and inclusion. For example, the State Bar's lobbyists did not provide itemized expense reports in the past. Were the State Bar's lobbyists' expenses made for the purpose of limiting the State Bar's discriminatory admissions activities? That seems highly doubtful. The auditor's reports have also shown us that the State Bar has spent its income for alcohol at its events in the past. Was that alcohol used to improve diversity, equity, and inclusion in the legal profession? That seems unlikely. The state auditor's report also criticized the State Bar's multi-million-dollar contract grant to ExamSoft, a company known for its unreliable software and facial recognition technology that disparately impacts people of color. As an alternative to increasing its fees and spending more money studying its own discriminatory activities, I urge the State Bar to instead put an end to those very activities. For nearly a century, the State Bar has contracted with the NCBE to develop the bar exam, a private Wisconsin corporation run by homogenous attorneys who are beneficiaries of a program that allows them to skip the bar exam before going on to run the very corporation that produces the nation's bar exams. If the State Bar immediately implemented a similar non-exam pathway for admission, it would not need to increase fees and would also vastly improve diversity, equity, and inclusion in the legal profession. Thank you.
Thank you, sir. Next we have
David Carr.
Good morning, Mr. Carr. You may begin.
Okay, I hope you can hear me. My name is David Carr. I'm a California lawyer, and I speak to you today based on 33 years of experience in the discipline system, including 12 years working at the State Bar and more than 20 years defending lawyers in State Bar discipline proceedings. The board should not advocate the proposed change in Business Professions Code section 6007 that's on the proposed legislative agenda. This proposal would allow the functional equivalent of imposing discipline without many of the traditional due process protections afforded by Supreme Court precedent and State Bar Court precedent. These include discipline without a full trial, discipline based on a significantly less stringent burden of proof than we have currently, and without the opportunity of full Supreme Court review. Unlike current remedies for ongoing harm, involuntary inactive enrollment could be imposed for conduct that occurred many years prior based solely on the likely level of discipline and not based on a finding of ongoing harm to the public. This is an unfair proposal. Public protection is the paramount value of the discipline system, but it's not the only value. The board has recognized this in the creation of the ad hoc committee. Robust interim remedies already exist for ongoing harm. This proposed change is not necessary to protect the public, and I would strongly urge the board not to advocate this as part of its legislative agenda. Thank you for your time and attention.
Thank you for your input, Mr. Carr. We have a third member of the public.
Yes, we have Pete Bennett.
Good morning, Mr. Bennett. You have 3 minutes to address the executive committee.
Good morning, members of the committee. Do I come through okay?
Yes, you did.
Thank you. I come to you today with disturbing allegations and situations. I am a litigant, plaintiff, defendant, arrestee, and also targeted person in the kind of a way that I've been beaten up plenty of times in Walnut Creek for the most part. I worked with the California Department of Justice for well over 10 years. In the middle of this investigation, I was part of the PG&E explosion, which I put on my blog called pgewitness.com. And I'm very disturbed about how I've been redlined and things like with the court-ordered ethics monitor with judgealsup.com, which is where my other complaints are. Literally, I don't want to use the word, but I've been harmed immeasurably. I have witnesses in my civil cases being killed. My attorney was Mark Angelucci. My friend was found in Joshua Tree. My witnesses are being killed, ladies and gentlemen. And it's unacceptable that I've had to go through all of this, be arrested, be beaten, and have my family murdered in Utah. My friend was the American killed in Barcelona. How did I get there? And Miss Delon, I was the one that ran the protest at Bank of America in Concord with Kevin Flanagan. I got a job at Wells Fargo Bank when the programmer jumped off the Bay Bridge. I have tried to get through to PG&E to get paid for the last 10 years. Instead, I go to jail. I have a clean record. My documents and files and everything I have has been stolen. FBI, State of California, you can send an email to tau@chp.ca.gov. I've sent them 1,000 emails. This has gone on so long. Unacceptable. I can't win in a courtroom. That's why I created ContraCosta Bar Association.com, and I'm not done. I'm going to show you how attorneys have been killed. I'm going to show you how people are losing in courtroom. And this has gone on. And I've communicated with the Bar Association as far back as 10 years. Gone on too long. This is unacceptable. My life is valuable. I will die on the street. I will. It'll be over for me. And Mr. Stallings, look up David Overhofer from McFarland. I know that guy. He's a crook. He's the chief of police. That person's a huge problem for me.
Sir, your time is up.
Thank you very much.
Okay, I'll double check to make sure there's no one else from the public has indicated a desire to address the committee.
We do not see any other hands raised.
Thank you, Madam Secretary. Moving on to our agenda, I will forego the chair's report in the interest of time, and I'll be making a report later at the full board meeting. That takes us to the consent calendar. We have one item, which is our open session minutes from January 20th, 2022. Does any member of the committee have any questions, additions, or deletions from the minutes?
I'll move adoption.
Motion by Trustee Cisneros. Can I have a second? Second by Vice Chair Stallings. May we have the roll call, please?
Chen? Yes. Cisneros?
Aye.
Delenn?
Yes.
Sol?
Yes.
Sol?
Aye.
Stallings?
Yes.
Motion carries.
Thank you. Takes us to item 3A on our business agenda, the approval of the 2022 legislative priorities. We've got Donna Hershkowitz and Bridget Grammy to present. Thank you.
Good morning, Mr. Chair and members. Can you hear me?
I can hear you. I'm not sure about the mic.
Arnie, Sonia, can you hear me? Great. I've got a PowerPoint that Louisa is going to be putting up. We'll get started with the introduction while Louisa is getting that ready. So each year, staff recommend affirmative legislative proposals for board approval. With this approval, staff then continue to develop the proposals, conduct additional research, engage key stakeholders on the issues, and determine whether and how to pursue these priorities during the current legislative session. And the clicker's not working. There we go. So today we're bringing 8 affirmative legislative proposals for the board's consideration as legislative priorities. We're also bringing 1 piece of legislation on which we are recommending a support position. And this reflects a slight update from the agenda item that's in the materials. The members here have a draft, have a red line of revised resolutions in front of them, as do the members who are participating remotely. And we will be showing those as well during the PowerPoint. So 2 of the proposals that you have that we'll be presenting today are for legislative priorities relating specifically to the attorney licensing fee. 3 relate to changes to improve the fairness and effectiveness of the discipline system. 2 support the State Bar's mission to increase access to legal services. And 1 relates to support for lawyers. We intentionally went into great detail in the agenda item, so we will do our best to keep this presentation at a somewhat higher level. So starting with the annual attorney licensing fee, we are recommending the adoption of 2 legislative priorities specifically related to the fee. The first would authorize staff to explore, including in the annual fee legislation, an inflationary adjustment that's intended to cover the natural increases in costs that occur year over year. In 2020, as many of the board members know, the State Bar saw its first increase in the fee amount in over 20 years. Yet over those 20 years, labor costs rose, cost of equipment increased, cost of day-to-day operations increased, and not just by a small amount. The State Bar simply could not survive another 20-year period without increases. The budget approved by the board last month reflects the impacts of inflation and the growth in costs. The budget projects expenditures exceeding revenues by $3.9 million, eating further into the State Bar's reserves. According to our finance office, if the inflationary adjustment were attached to the fees already, the inflationary adjustment from 2021 to 2022 would have been sufficient to keep us from projecting a deficit. And as we are about to embark on labor negotiations for a successor MOU to the current one, which expires at the end of this year, we've already been informed that the union intends to seek a large inflationary adjustment for employees. And so we think the only thing that the bar can do, that what the bar must do, is to seek an inflationary adjustment, an annual inflationary adjustment, to ensure that there is an annual adjustment in the amount of the fees to address those increasing costs. The second proposal related to the annual licensing fee is asking the board to adopt as a legislative priority an increase to the fee revenue that's earmarked for diversity, equity, and inclusion initiatives. This is currently funded by a $2 opt-out in the licensing fees, yielding just over $300,000 per year. The 2-year DEI plan that was submitted to the legislature, identifying State Bar plans to improve diversity and inclusion in the profession and work to eliminate bias in the workplace, included a need for $425,000 of additional ongoing funding needs to support the State Bar's DEI initiatives and have a meaningful impact on the legal profession. This legislative priority would support a nominal increase in the licensing fee, either to be shared by all attorneys or only those who do not opt out of the DEI expense to help meet the State Bar's goals.
Okay, so I'm going to cover, sorry, can you hear me? Sorry. The discipline system fairness and effectiveness proposals that we have. We have three. The first one has to do with amending the statute, the vehicle code, to allow the bar to access the photos from DMV files. We used to have access to this a long time ago, and then the DMV changed their policies to only permit law enforcement. And because the bar does not have sworn investigators, their position is that we do not count as law enforcement. So we've been denied access to these photos, which are important for investigations. And so we are requesting a specific statutory amendment that would grant access to these photos. We had another item in the memo that we're now taking off that would have given made confidential home addresses of OCTC investigators and attorneys, but upon further conversations with the DMV, we've learned that these addresses are already confidential, so we've taken that off. The third one has to do with protecting the public from substantial risk of harm. This is Business and Professions Code Section 6007 C2. And in this one, OCTC is proposing that we amend the statute to allow the State Bar Court to authorize involuntary inactive enrollment for attorneys who have caused or are causing a substantial risk of harm. But the current standard now is that they also have to show it's reasonably likely that the attorney would be disbarred. And what we're trying to do is amend it to say reasonably likely that they would be have a suspension of at least 12 months. So that allows us to use this really important public protection tool in additional cases. We've been asked by the legislature several times why we only have a limited, why we only use this very rarely. As we put in the memo, about 11, we've used this, OCTC has requested this for 11 attorneys from 2017 to the present. And so we want to be able to expand our use of this tool. I do want to let you all know that we've had conversations with the State Bar Court. They disagree with the example that we provided in the memo of an attorney where they've misappropriated $100,000 in client funds, but didn't have prior discipline. In our explanation, we were saying OCTC did not believe it was reasonably likely that they could prove disbarment, that disbarment would be likely, so they wouldn't pursue, a temporary suspension of practice. And the State Bar Court disagreed with that example, but I did go back and check with OCTC, and this is based on an actual case where that happened. In fact, this case had over 100,000, and there were some prior records of discipline, but did not rise to the level of intentional misappropriation. And so, and in that case, they were only given 2 years of suspension. It was not disbarred. So it just goes to show, if anything, that there's not clarity around this, and we want to just be able to expand the ability to ask for temporary suspension if we think there's substantial risk of harm. So I've committed to work with the State Bar Court to find out more information about how it might impact the court, but we still would like to move forward with this legislative priority. And then the last one that we have on here is the legislative arm of the client trust account protection program. And so most of as you've been hearing about this from the special discipline case audit committee, their recommendations mostly can be implemented by rule, which you'll be hearing about later today. But there are a few legislative priorities that we would need to address in order to make the whole program work. One of them is to require banks to report to the bar about all client trust accounts that they have, not just IOLTA accounts or accounts that have been overdrawn. Another addition would be to require attorneys to engage independent CPAs and to make sure that their compliance review of their client trust accounts are up to code. And then also would permit the bar to do audits of client trust accounts. So we've noted in here that it would cost additional funds, and for us to be able to do that, we don't have the funds in existing general fund right now. But those are the main proposals for the discipline system.
The next two legislative proposals relate to access to justice. They both actually reflect attempts to shrink the justice gap by improving recruitment and retention in legal services, consistent with objective Q of goal 4 of the strategic plan that will be sunsetted maybe today or tomorrow with the board's action. The first one has to relate to strategic funding for legal services. Effective with the 2021 attorney license year, the $40 voluntary contribution for legal services that is paid along with the annual fees was increased $5 for the specific purpose of providing grants to legal services organizations to hire provisionally licensed lawyers. With the sunset of the provisional licensure program this coming June, that $5 increase was set to sunset. Legislative staff, seeing that the $5 increase has not led to an overall decrease in the contributions, has proposed keeping that permanent, and they proposed to roll it into the $40 so it would all be distributed pursuant to the IOLTA formula to the 100+ organizations. State bar staff, Legal Services Trust Fund Commission, Access Commission, California Change Lawyers, and the Legal Aid Association of California all got together to figure out if we could identify a strategic use of that additional $5 because it's not ongoing money that the legal services programs have all expected in their budget. And they all concluded that something that would make a real meaningful difference is paid internships for law students for summer programs so we can prevent law school drift. There are a lot of law students who are interested in going into public interest, but cannot afford a volunteer summer and find themselves being pulled to the private sector. And once you start there, it's hard to return to the public sector. And so this would provide an opportunity to get these law students who are interested in public service into legal services organizations during a law school summer, so then they would be incentivized to continue and stay in legal services going forward. The next priority in this area also seeks to improve recruitment and retention in legal services, and it involves the adoption of a loan repayment assistance program, something we've been talking about here at the bar for a while. It was included in the rationale for why we were doing the justice gap study, which we added to the strategic plan back in 2018. And so this is also a joint effort. We have been working with the State Bar's Council on Access and Fairness, Legal Services Trust Fund Commission, Access Commission, and Legal Aid Association of California to develop parameters for a loan repayment assistance program that would provide enough funding to make a real difference to those who are in law school and considering whether to begin a legal services career, or those who have previously committed to legal services, but due to the circumstances of their life, due to the loan debt that the crushing loan debt that they are facing, find that they cannot stay in legal services. And so this would be a plan to improve recruitment and retention. We are working on the final details of the plan, but are very excited about the mutual agreement on how to approach this. We've also been in communication with the California Student Aid Commission to see who might be the best organization to administer this program, and we'll be continuing those conversations. And so that's it for the two. Oh, this is the wrong PowerPoint. So there's the one final priority is support for lawyers. This is a very short one. It's a technical cleanup to the Lawyer Assistance Program authorizing statute, simply to clarify that the statutorily required outreach efforts to make lawyers aware, the statutorily required outreach efforts to make lawyers aware of the services that are provided by LAP and to provide education about substance use and mental health issues. Also includes outreach about other behavioral health or wellness issues, cognitive decline, process addiction, and the like. So that's it for the legislative priorities. We also have we're also requesting the board's authority to take a position on pending legislation. Bridget?
Yeah, so this is one bill, it's AB 1733 Quirk, which would allow the board to continue operating, or all boards subject to the Bagley-Keene to continue operating with Zoom or the like teleconferencing. It would remove the requirement that you have to show, list the addresses where board members are participating remotely. Board members would have to disclose if there's anyone in the room above 18 years old that are in the room with them. But it would allow us to continue to go forward as we have been. It would also, we've noticed a big increase in public participation since we've been doing this, and also a decrease in cost for having to have all of our meetings in person. And so we would recommend that the board support this bill. And it would go into effect. It has an urgency clause in it, so it would go into effect immediately.
And with that, we have the resolutions. As I said, you have in front of you a red line copy of the resolutions, and they're also, the red lines are here on the screen. It's just minor differences with what was presented in the agenda item and what we're presenting here today. In case the committee chose to wanted to take positions, different votes on different items, that's why we broke them out here. Committee is, of course, is free to lump them all together into a single resolution. So these are the two priorities related to the attorney licensing fee. Then we've got the three priorities related to the discipline system. The two priorities seeking to improve access to legal services for low and moderate income Californians. One priority to clean up the lawyer assistance program statute. A resolution recommending a support position on AB 1733. And then two, and this one's mildly different too. Two resolutions delegating authority to staff in consultation with the board's legislative liaisons to take these priorities to the finish line and to take action on pending legislation in between board meetings. There's a slight, in what you have in front of you, item number 11 looks a little different than it does on the screen. And item number 11, the one that is in front of you, is what we were proposing based on conversations that we've had with the legislative liaisons.
Thank you, Ms. Herskowitz. Ms. Grammy. There's quite a bit here, and I certainly want to encourage the executive committee to feel free to ask questions of staff if you need clarification on any of the legislative priorities and potential actions. I appreciate the fact that the resolution breaks them up sort of categorically, and so why don't we approach it that way if the board doesn't mind. Could I get the first part of the resolutions up on the screen? If you have a question or a comment related to the attorney licensing fee portion of this agenda item, please let us know by indicating raising your hand if you're here in the room. If you're on Zoom, trustees Delenn and Soel, let us know if you'd like to ask a question, make a comment. I see none from the virtual world. Mr. Stallings has his hand raised.
All right, thank you. Just want to thank staff for their work on this. My question is in regards to the fee adjustment for inflation. Have we seen any other public entities take an approach like this to any fees that they collect?
So I was looking through the legislation that's been introduced this year, and this is something that we've seen in past years, and the legislature in the executive branch in past years, departments got what was referred to as a quote price increase, which it was a CPI adjustment for office expenses and equipment. I am not certain that price increase still exists for executive branch agencies, but that is something that was given yearly. This year, the one piece of legislation that I noticed that it included an annual inflationary increase was actually for I believe it was for the wages that are provided for working in the prison laundry, et cetera. So that's the one that I noticed looking through all of the introduced legislation this year. And it is something that we've requested before. It was part of the discussion with the California State Auditor and the legislative analyst when we were seeking the fee increase in 2019. And the memo goes into some detail about the Legislative Analyst Office reaction to that request, but the reaction had nothing to do with this is unheard of in state government. That was absolutely not the response there.
And just a clarification, the CPI adjustment is statewide CPI. It's the amalgamation of the various indicators, or is it tied to one of the metropolitan areas, for example?
So we would work with the legislature, our Office of Finance, Department of Finance, et cetera, to identify what the appropriate inflationary adjustment would be. I had our Office of Finance just give me their understanding of what the inflationary increases have been over the past 5 years, and that's spelled out in the memo, and what the increase was over the past year at 4.7%. I don't recall if they were looking at the CPI for the San Francisco metropolitan area, the CPIU, but that's something that we would work out the specifics. I would imagine that the legislature has a specific formula that they would use and that they would be comfortable with.
Okay. Any other questions on this portion of the presentation? Okay, can we move down to the next group of issues?
Yeah, and I believe Chair Duran, that Louisa switched to the Word version because Donna's indicated there were some errors in the PowerPoint slides that she had up. So this way we can make sure the resolutions actually reflect what is intended to be adopted. So I think Bridget can walk us through which ones are now the discipline items. I think it's 3, 5, and 6.
Yes.
Right. Okay. And Donna, although it may be awkward, maybe just read out if there are any needed edits to the resolutions here.
So the only change from what's in the agenda item is the striking of number 4, which Bridget had explained related to the address confidentiality program, that we no longer believe that we need legislation in order to protect the addresses of our investigators.
Thank you for the clarification. Thank you, Madam Secretary, for being nimble. We may require some more of that as we move on. Any questions on the disciplinary standards issues?
I just think there, item number 5 could be clarified. In reading it, it to me doesn't, it's more confusing than was in the broader explanation. And in particular, the last phrase after the last comma, and not simply disbarment, I find confusing and ambiguous there. And also because it suggests that all you need is a reasonable probability of suspension of 12 months, and it leaves out the first part of the statute, which requires the risk, or what I can't remember the term, substantial harm. So I just think the language could be clarified to make it clearer.
Thank you, Trustee Chen. I have a question on this one, actually. So as part of your presentation, Ms. Granby, you noted that looking back, the determination was made that between, I think you said 2017 and the current date, there would have been 11 cases affected. If we adopt this different standard, do we have any sense, even a ballpark, of how many more suspensions there would have been?
OCTC estimated double the amount, but that was just our
Kind of like
guess.
spitball. Yeah.
But it's still, I mean, it goes to show it's still like in very extreme circumstances, it's not going to open the floodgates of us using this. And it still does require, you have to make a showing to the court that you have substantial harm. It's not just like take away a license without any kind of due process. And they would still continue to go through the discipline proceedings. It's just that they wouldn't be able to practice while that's happening.
Thank you.
So if I could suggest what the wording change to that resolution would be. Further resolved that the Board Executive Committee recommends that the Board of Trustees adopt as a further legislative priority, increasing public protection by amending Section 6007C2 of the Business and Professions Code to allow involuntary inactive enrollment where an attorney has caused or is causing substantial harm to their clients or the public, and there is a reasonable probability both that OCTC will prevail on the underlying misconduct matter and that the attorney will be subject to an actual suspension of 12 months or more.
Good. I feel like that satisfies my concerns.
Thank you.
Substantial harm.
Yeah, I think you need to read it a bit more slowly.
Yeah. An attorney has caused or is causing substantial harm to a member of the public.
Yes, so where are you? And these are my distance ones.
An attorney has caused or is causing.
Okay, where an
substantial-
attorney has, where an attorney has caused or is causing substantial harm to their clients or the public.
To their.
And.
And
Let's see, then
No,
you
after
keep- you-
public and. After public.
There you
And
go.
then keep the next part all the way until reasonable probability, after probability. Both that OCTC will prevail on the underlying misconduct matter. And then at the very end of the next line, after, end it after more, just take off the rest.
Thank you.
Perfect.
I think so. I also just have another comment on the, is number 6 part of what we're discussing too?
Yes.
I would prefer to write out client trust account protection program. I just find that acronyms become alphabet soup, and I think the public and also members of the board sometimes are like, wait, what does this refer to?
I also think we are pursuing and not pursuing
I noticed that,
legislative
yes.
changes. Okay. Thank you, Madam Secretary.
There are no more questions on the discipline system ones. Number 7 and 8 are the access to justice. And this, there is no difference between what's in the memo and what you have here on screen.
Any questions on this portion of the agenda? Any comments? Mr. Stallings?
Just a question about on number 8, just wondering if COAF has been consulted about some of these proposals and if they've had, if they're going to be joining in support of these legislative priorities.
Yes, so number 8 stemmed from a working group that we created between members that included members of the Legal Services Trust Fund Commission, COAF, and the Access Commission. And the members of COAF were involved in the last call that we had a couple of weeks ago, identifying what the proposal is, and we're very supportive of us moving forward with that proposal. They're very excited about the opportunity to increase diversity by providing loan repayment assistance.
Great, thank you.
Trustee Sowell?
Just a quick question. Donna, you mentioned some work with the Student Aid Commission, I think around this, around number 8 as well.
Mhm.
Whatever is developed in terms of the program that potentially moves forward, is that something that would have to come back before the board for us to approve, or how will we get some insight into what's eventually decided here?
So that's, we will get to that part when we talk about the 2 resolutions that involve the delegations to staff in consultation with the legislative liaisons.
Very
But,
good.
but I do think, Arnie, on at a very practical level, one of the ways that we have identified to advance this effort is to use some of the proceeds from the sale of the San Francisco building to support the loan repayment assistance program infrastructure. And that, of course, would need to be approved by the board in and of itself. So I think there will certainly be opportunities for the board to weigh in on the program as it unfolds.
I have to say that all of this is tremendously exciting to me. And it's not a lot of money for what I hope will be a lot of impact into the pipeline in particular and retention for law students. Just curious, the $5 that would fund legal services interns, you mentioned collaboration with that community of service providers. Any sense from them of how many of them are going to take advantage of this? How many budding and new lawyers will get into this very important work?
So the math that we did, assuming a $15,000 stipend for each fellowship, I think we were talking about potentially 40 to 50 summer positions that would be fully paid. Some positions are currently paid by law schools. There are some programs, but by bringing 40 to 50 people in who otherwise would not be able to afford this program annually can make a significant difference in the ranks of legal services lawyers.
Absolutely. That's wonderful. Thank you. Okay, I think we have a couple more
Yes.
provisions here, right?
Resolution 9 is the cleanup to the lawyer assistance program language under the headline of support for attorneys.
I would just ask that we write out lawyer assistance program.
Certainly. Number 10, and this is new and not included in the agenda item, is taking a support position on Assembly Bill 1733.
Any questions or concerns on either of these? Okay, let's keep rolling.
And the final two, 11 and 12, deal with the delegation of authority to staff in consultation with the board legislative liaisons to take the next steps on each of these legislative priorities. And also because of the legislative cycle and the urgency with which things happen, authorizing staff in consultation with the legislative liaisons to take action on pending legislation in between board meetings, so long as it's consistent with the strategic plan, and that we bring to the board at the very next board meeting, we indicate any legislation on which a position has been taken. Number 12, about the positions on legislations in between meetings, is an addition from what was in the memo. And then in number 11, you will see a red line. We've added a phrase after delegating to staff. We've said in consultation with the board's legislative liaisons and as informed by feedback from relevant stakeholders where appropriate. And that is what is added since the memo was printed.
And I'll say that the addition of the feedback from stakeholders was that modification was made directly in response to some of the concerns that have been raised about the 6007 provision. So we do want to engage in some due diligence around that proposal.
Trustee Sewell, you have a question or a comment?
Just a quick question on how this delegation in between meetings would occur. Donna, does that mean, and I'll take an extreme example. We've taken a support position of AB 1733, but let's say Mr. Quirk decides that to completely amend that bill to something else. Would that allow the legislative liaisons to either, remove our support, at that particular point in time, and then come back to the board and let the board know that change had occurred?
Yes, that absolutely would be one of the types of things that would come to the legislative liaisons that we would do in between meetings. The other thing would be other bills that get amended into the jurisdiction of the state bar that aren't currently, and so we haven't raised them to the board for a position up until now that we would want to take a position on. And there's a hearing coming up, and so there is not time to wait till the next board meeting.
So as long as we're on this topic, I would like to take a moment to recognize the legislative liaisons and to say thank you on my behalf and if I could, so staff's behalf for the work that group has been doing just for openness and transparency. That includes trustees De La Cruz, myself, Duran, Shelby, and Soel. And that is and has been a pretty active and I think good working group together. So I look forward to continuing that work. Any other questions or comments? Trustee Chen.
So on number 12, I do wonder whether we should also include mention of the State Bar Legislative Program, Purpose and Guiding Principles, which I noticed was attachment A to the agenda item. It does set forth guiding principles and goals that I guess were adopted in January 2018. And so it would seem to make sense to reference that as well. Separately, I think we should consider for future discussion whether we need to amend those guiding principles given the passage of time and given that the first goal talks about successfully transitioning the new state bar to an agency focused on public protection. And then the other thing I will note is that it does not, these principles do not specifically call out diversity, equity, and inclusion as a goal. I know that in the past we have thought about it as falling under access to justice, but given our recent discussions and our strategic planning sessions, it's probably time to take another look.
Yeah, and that's why we didn't reference it here is because these are so outdated.
Yeah.
This was done before we expanded goal 4 to specifically reference diversity. And so, but it's a good reminder because Leah and I had spoken about the need to update these. And so maybe that should be the resolution. An additional resolution is that staff come back at the next board meeting with an updated document indicating the purpose and guiding principles of the legislative program.
Yeah, I'd like to see that change if we could, please. Okay, while the secretary is getting that language in, I'll just take one last look around to see if there are any questions or comments. The further resolution is that staff come back to the board at its May Board of Trustees meeting with revisions to the document that Trustee Chen
With
pointed
the
out.
document included as attachment A to the memo.
Thank you. To attachment A. Gotta love drafting on the fly. You have my admiration. Okay, if there are no more questions, may I have a motion on this resolution, please?
Mr.
Sonia Dellen here. A motion.
Trustee Delenn with
I
the,
move.
and I see Vice Chair Stallings is eager to make a second.
I'll make a second.
Can we have the roll, please?
And this is for all of
This is for
13.
all the resolutions as amended here at the board meeting.
Yes, for all.
Thank you.
Chen,
Yes.
Cisneros,
Aye.
Delenn,
Yes.
Sol,
Aye.
Stallings.
Yes.
The motion carries.
Okay, thank you, folks. That'll adjourn our executive committee meeting and we'll have the finance committee come up and take their places and get started quickly because we are just a little bit behind so far.